I'm Jennifer Lowe. I'm the Director of Programs and Strategic Planning here at the Supreme Court Historical Society. We're delighted to have you on our virtual platform this evening for a terrific conversation with Brad Snyder and Laura Kalman. I'm going to start a video welcome from our Executive Director, Jim Duff. If you just give me a moment to make Zoom magic happen, maybe. There we go.
Good evening. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society. A scheduling conflict prevents me from joining you live this evening, but it is my honor to welcome you to our virtual platform for tonight's lecture. The Society was founded in 1974 by then Chief Justice Warren E. Burger. It was founded to improve the public's understanding about the Supreme Court, Constitution, and the judiciary. Tonight, we feature a conversation between Professors Laura Kalman and Brad Snyder in celebration of Laura's newest book, FDR's Gambit, The Court Packing Fight and the Rise of Legal Liberalism. Laura Kalman is a distinguished research professor of history at the University of California, Santa Barbara, and a member of the California Bar and past president of the American Society for Legal History. She is the author of many other books, including The Long Reach of the 60s, LBJ, Nixon, and the Making of the Contemporary Supreme Court, Right Star Rising, A New Politics, 1974 to 1980, Yale Law School and the 60s, Revolt and Reverberations, The Strange Career of Legal Liberalism, Abe Fortas, A Biography, and Legal Realism at Yale, 1927 to 1960. She is currently working on the Warren Court volume of the Oliver Wendell Holmes Devise. Tonight's moderator is Brad Snyder, professor from the University of Georgetown University Law Center. Brad is a familiar face to our members, having delivered lectures previously for the Society, and he serves as a member of the Society's Board of Editors. Thank you for taking on these duties this evening, Brad. We welcome you both, and professors, the Society's virtual floor is yours.
Hi, Laura.
Hi, Brad, and thanks for hosting me, and thanks to the Supreme Court Historical Society for hosting us.
Yeah, I wanted to thank Jim Duff, obviously, Jennifer Lowe, who does just a tremendous job with programs, and Chilton Varner, who's with us virtually, the president of the society. And I just want to thank you, Laura, for giving us another book. And I've been reading your work for a long time. I tell everyone that if Laura's not the best living legal historian, she's one of the best living legal historians. So it's really the honor's mine to be doing this with you. And I hope we have a fun conversation about court packing. I think it's the most important kind of inflection point for the court as an institution, and the way we look at the court. And so I wanted to ask you, because there's been a lot written about court packing, and I bet you a lot of people, when you told them you were going to write a book on court packing, they said, do we really need another book on court packing? And so my first question is, like, how does your account differ from the standard ones? You had Alsop and Catledge did kind of a living history, a history at the time. Then you had Luchtenberg and Cushman and Shezel, etc. And most of these people are portraying court packing as FDR's biggest miscalculation and failure, but you portrayed as kind of a risk that was worth taking. Yes. Tell me why.
Well, it's understandable that they would have portrayed it as such a terrible blunder. Here you have FDR having this incredible victory in 1936, standing before the American people at its inaugural in 37, saying he sees 1/3 of the nation ill-housed, ill-clad, ill-fed, leading them to expect more relief, recovery, and reform legislation. Instead, what does he propose? A statutory remedy that will enable him to make to have up to 44 new federal judges and up to 6 additional justices to the court. And to make matters worse, he does it under a good government rationale. The court is behind its work. It needs help. It only hears 13% of the petitions that are submitted to it. His real reason, as everyone recognizes, is that he hasn't had a single vacancy during his first term. He believes that there are 6 justices over the age of 70, 5 of whom he sees as terribly conservative, and he believes they're staying on to thwart him. And because everyone realizes that that's his real reason, a firestorm ensues that makes the League of Nations battle look pretty tame by comparison. FDR is denounced by progressives who have been criticizing the court as the bastion of economic privilege for 30 years. Though he has huge coattails, 89 Republicans in the House and 16 in the Senate, Democrats are up in arms against him. He's accused of disingenuousness and political trickery, ignoring the fact that a constitutional amendment could do the job more legitimately, disrespecting the aged, disrespecting separation of powers, harboring dictatorial ambitions, endangering states' rights and individual liberties, and jeopardizing judicial independence. And the court bill goes down to defeat by a vote of 70 to 20. You can see why it's been portrayed as such a terrible blunder. The magnitude of the defeat makes it look really foolish. But I maintain that if you don't use hindsight, but study the event, the fight as it unfolded, FDR doesn't look like he's so full of hubris. Rather, he is displaying in the court fight some of the same smarts that enabled him to win this huge victory in 36, despite antagonistic elites and an antagonistic press. And as I show, on virtually every day of the 168 days that he battled with Congress, he could anticipate some success. In February, it looked as if he'd get exactly what he'd want. In March, it looked like Congress would happily give him 2 justices. In April and May, offers of compromise abounded, and they go into June when FDR finally indicates a willingness to compromise. Into July, it looks as if FDR will get 5 new justices, 1 a year. So further, it's the only remedy he can have. A constitutional amendment will take too long. The court may interpret it restrictively, and conservative interest groups are ready to fight it. So from FDR's vantage point, if you look at the fight as it unfolded, I think it was a good political gamble to choose a statutory remedy. And if some success was possible for so long, why should we remember FDR's effort as the arrogant overreaching of a president made overbold by a tremendous electoral victory. Further, as FDR pointed out, the court did change. It became more liberal on due process, the Commerce Clause, the taxing and spending power. Now, to be sure, as Barry Cushman and others have emphasized, there were very plausible doctrinal reasons for its journey. But like FDR, I think he had an impact. I think that his tremendous victory in 36 and the threat of the court packing plan may have helped move the court to become more pliable. Now, of course, there were also losses. He lost Congress as a result of this. But I think from his perspective, it was nevertheless a good and wise gamble.
So I want to ask you about the last thing you just said, which is Congress. One of the amazing things about your book, Laura, and I told you about this at the time, and I told you about this when I read this in draft, was the idea you had to look at court packing through the eyes of the members of Congress, and particularly some really important United States senators. And tell me why you decided to do that, and you know why it was important to kind of. I mean, I know what an archival, you know, great archival historian you are. You leave no stone unturned. Tell me and tell the audience, you know, where you went, your journey, right, in uncovering senators' papers, because I know it took you all over the country.
Well, to the first point, why did I go through it? Go in that direction is most accounts focus on the fight between FDR and Chief Justice Hughes, who, as FDR acknowledged, was as good a politician as FDR was. I wanted to look at Congress because Congress was where the votes were or weren't for the court, for FDR's court bill and the compromise solutions that followed. And I also wanted to look at interest groups that made themselves felt in Congress, like the Frank Annette's group, the National Something for Independent Constitutional Government, and an organization by white shoe lawyers like Grenville Clark and C.C. Burlingham to promote independent courts. So I was interested in looking at Congress. I figured that was where the fight was. The fight was in the Senate because the House had refused, Hatton Sumner, who was the chair of the House Judiciary Committee, had refused to take it up until the Senate finished. So where did I go? Well, it was frustrating, and my archival journey was frustrating and fun. I started in Montana with Burton Wheeler, whose papers are divided between Helena and Bozeman. And I couldn't find a car to rent in Helena, so I had to take a $200 Uber ride to Bozeman, which was not nearly as bad as the $600 Bozeman Uber ride I had to take from the Frank Annette papers at Cornell to the Grenville Clark papers at Dartmouth, but was still disappointing because, as you know, Wheeler's papers aren't that revelatory. Then I went from there to Laramie, and I was really excited about that because though that was where the papers of Joseph O'Mahony were, and he was a great opponent of the court bill, another progressive who opposed it. And in an earlier article that Jean Bresley had written, I had seen reference to O'Mahony's diary. So I was just dying to get my hands on the diary. Well, when I got to Wyoming, the archives had moved and O'Mahony's diary had been lost in the process. So there
Oh, my
were
goodness.
other stuff. The Library of Congress is very good for senators like William Borah and Robert La Follette. And I loved going to Fayetteville to look at the papers of Senate Majority Leader Joe Robinson, who loyally fought for the plan, even though he was insisting on a diet of buttermilk because he had intestinal flu and would die championing the plan. I loved reading his letters to his wife and his brother-in-law and his great friend Bernard Baruch about the plan. But the pandemic made everything very difficult. And for example, archives shut down. I was only able to get one day at the Hiram Johnson papers in Berkeley. And they shut down for a long time. So, I had to rely on archivists and research assistants who were wonderful.
Well, that's an amazing story, Laura. And I think I'm going to get you a Hertz Club Gold membership for Hanukkah or something, because I can't believe you took Uber rides that cost $200 and $600. That just kind of made me laugh.
$600 hurtling through from Ithaca to where is Dartmouth?
Yeah, in New Hampshire.
Yeah, to that, wherever it is, in the middle of the night, thinking I'd never make it again. It was awful. But there were also the Homer Bone papers that I persuaded my husband to take a trip to the Northwest to see at the University of Puget Sound.
That's amazing. Can we talk about Burton Wheeler? Because I feel like sometimes, as you mentioned earlier, people make this about FDR versus Hughes, and I feel like Burton Wheeler, first of all, was a giant in the Senate, and had an incredible career and some ups and downs, but can you talk about his role as kind of the leader of who I view as the leader of the opposition in the Senate, and just what his machinations were, and in doing that, can you tell the story about Mrs. Brandeis, because it's one of my favorites?
Sure, I'd love to. Well, Burton Wheeler is one of the great surprises for FDR. I think the progressives like Wheeler opposed the court packing plan with even more intensity than FDR anticipated. And Wheeler would not have been expected necessarily to denounce the plan. He had been criticizing the court for 30 years. He had run for vice president as the progressive candidate in 1924 on an anti-court platform. He was the first big Democrat to come out in favor in the Senate, to come out in favor of FDR in 32, and he had actively campaigned for FDR while denouncing the court and promising that there would be four new justices. He didn't say whether they'd be new or they'd be additional in 36. And then by Valentine's Day, the plan is proposed on February 5th. By Valentine's Day, Wheeler has come out totally against the plan. And I think There were a few reasons for this. One is that he could not stand Attorney General Homer Cummings, who was often credited with birthing the plan. And Cummings's best friend was someone that Wheeler detested from Montana, J. Bruce Creamer. The other reasons were less petty. I think he was afraid of the centralization, like in the national government, like in the executive branch in particular, as many progressives were. He was also believed that it would, he always said, he says in his papers, that it would create a dangerous precedent that conservatives could use later. I think also he thought that FDR was getting too big for his britches. Remember that no one assumed that FDR would run again in 1940 at this time. And Wheeler, I don't know what you think about this, Brad. I think Wheeler may have had his eye on the presidency.
I don't know enough to know that. I mean, I was astounded that someone as progressive as Wheeler was, who was advised by, Max Lowenthal, right? This, Frankfurter protege, and Frankfurter, of course, being a huge FDR insider, would basically turn against the administration like this.
He's making common cause with the economic royalists, the conservative Democrats and Republicans against the court that he's been criticizing for so long. It seems bizarre. The Alice Brandeis story that I love, it relates to Mrs. Brandeis's opposition to the bill. Obviously, since Brandeis was the oldest justice at 80, he didn't like it. And Mrs. Brandeis apparently hated it even more than he did. Now, the Brandeises didn't normally make calls on people, but when Wheeler's daughter had a baby, Mrs. Brandeis called on Wheeler's daughter to admire the baby, and then said as she was leaving, "We approve of everything your father's doing to fight the court bill." And her car isn't out of the driveway before the daughter calls Burton Wheeler and says, "Brandeis is on our side." And so that gives Wheeler, who has known the Brandeises for years and been active in progressive causes with them, a reason to go to Brandeis. Now, Brandeis, in turn, then sends him to Charles Evans Hughes. Wheeler has voted against Charles Evans Hughes's confirmation as Chief Justice earlier, and he says to Brandeis, "How can I go see the Chief Justice?" And Brandeis says, "Don't worry about it. The Chief Justice knows what you're." I don't know him. Brandeis says he knows you. And so Wheeler goes to Hughes, and that becomes the impetus for the Hughes letter showing that the court, contrary to what FDR has said at the outset, is abreast of its work. Now, I don't personally think that the Hughes letter made as much of an impact as some people do, because everyone already knew that the court was up to date on its work. That had been leaked to reporters, but still the Hughes letter was important.
And it was a dramatic moment, right?
Absolutely.
Wheeler's reading it, he begins his testimony in the Senate Judiciary Committee, and he opens up this letter and he starts reading it. And then to read the three names who sign it, right, is Hughes, Brandeis, and Van Devanter. That's an odd couple, right? And like, I think people were shocked. Even people, including Felix Frankfurter, were shocked that Brandeis had basically publicly come out against the court packing plan for probably some of the same reasons Hughes did, right? Afraid of big government, federal government power, right? Not Hughes, I'm sorry. Burt and Wheeler did, right? Burt and Wheeler and Brandeis are old line progressives who believe in states as laboratories, and they're probably worried about FDR aggrandizing his own power, right?
Yeah, and further, Hughes creates the impression that though he's only shown the letter to Brandeis and Vandevander, the whole court approves of the letter.
Yeah, and I liked it and when Wheeler asked Hughes about the other justices, and Hughes's response was that Brandeis and Vandevander are the court.
The court,
yeah, that you don't need anybody else.
Yeah,
that was a pretty amazing statement. It shows how respected Brandeis was among liberals and Vandevander was among the Four Horsemen, right? So
and it made people like Stone very angry.
Very angry, very angry. So that's a neat moment in the book. I want to ask you about, I know this is a bit of a shift, and then we can talk about all of the other kind of things that made the court packing plan becoming a reality more difficult. But I want to know if you think that Roosevelt introduced the wrong bill, that if he had just introduced a pension bill, restoring the justices' pensions to their pre-depression full salary, that he could have gotten what he wanted without kind of looking like he was packing the court. This is, of course, you've written about this, and Judge Glock wrote a great article about this.
Oh, terrific.
Right, about why it was that no justices had retired during Roosevelt's first term. Could you talk about that?
Yeah, the Glock article is so great because it situates the retirement crisis in a long history of what do we do about the justices' retirement. When Holmes had retired, Congress had, in an excess of budget cutting, cut his pension. House Judiciary Committee Chair Hatton Sumner had tried to introduce a pension bill that would allow the justices to retire at full pay and would protect them in 35. The same privilege that lower court federal judges had, and it had failed. So when Sumner says in 1937, let me try this bill again, and some justices will take advantage of it, you can see why FDR doesn't immediately think it will work. Nevertheless, the Sumner's bill is put forward. It is approved by the end of March. The great thing about the Glock article is that he points out what many people haven't noticed about FDR's court bill, which is that the bill left the justices' fate in their own hands. If they waited, if they retired within 6 months of turning 70, and then there would be no new additional justices. And further, the court bill provided that nothing would happen until 30 days after the enactment of the court bill. So basically, as Glock shows, the justices' future was in their own hands. If they wanted to keep a court of 9, 6 of them could retire. Now, I'm not sure how effective this is. One of the cartoons I have shows Attorney General Cummings saying, well, if they don't like it, they can leave. You know, I'm not sure how, but I do think that a better retirement plan deserved greater attention from the beginning, and that the Roosevelt administration should have paid greater attention to it from the beginning, rather than letting Sumner's introduce it.
Right now, there are a lot of things that happen, most of which you claim at the outset of this talk didn't kill the court bill, right? The first is West Coast Hotel versus Parrish, which is commonly known as the switch in time, but which historians have disagreed on March 29th and 37. And then you get NLRB versus Jones and Laughlin on April 12th. And then Vandervanter takes advantage of Sumner's retirement bill and retires on May 18th. And then, as you alluded to, Joe Robinson, the person charged with shepherding this thing through the Senate, he dies, right? And yet you think that additional justices are still possible, and you sort of show this is still possible. You said he could have gotten 2 justices in March and 1 a year possibly in July, and yet FDR is a savvy politician, and why didn't he take these deals, right? Why didn't he just take 2 more justices or take 1 a year and just declare victory, say I win, right? And was that possible?
Well, he could have done that, but I think he was still into May. He was still thinking maybe he'd get the 6, and after that, he was thinking he'd get the 5, 1 a year. He had some tricks up his sleeve for the Senate Judiciary Committee that denounced him so violently that that there was sort of a boomerang reaction, and there was a reaction in which many people thought the Senate Judiciary Committee, which was headed, a majority of which was Democrats, had gone too far. And another trick, so that helped FDR. Another trick that helped him was his gathering of the Democratic faithful. This was Joe Robinson's idea at the Fish and Game Club, which sort of made them ashamed of themselves. Now, as to the
tell people what this Fish and Game Club meeting was. It was on the Eastern Shore, right?
Right. It was a Democratic Fish and Game Club, and all the Democratic men, not the women, are invited out for the weekend and the invitation, and they don't know what to expect. This is one of Bill Luttenberg's marvelous articles. They don't know what to expect. Are they going to get there and FDR will lecture them and read them the riot act? You disloyal Democrats. No, they get there and FDR has arranged a giant party for them. So he's got tricks up his sleeve. As far as the things that you've alluded to, I think Gregory Caldera's careful study of West Coast Hotel versus Parrish shows that the court's switch in time didn't make that much of a difference. But the labor board decisions, which appeared to many contemporaries to signal a reinterpretation of the Commerce Clause on April 12th, did make a difference. And so did Vandervanter's resignation on May 18th, which had been arranged with Wheeler and William Borah, all the forces opposing court packing, to give FDR a vacancy on the court, so you could say, see, you've got this vacancy, what do you need for the court bill? So then you add to that the Senate Judiciary Committee report and the party at the end of June, and FDR still has reason for hope.
Yeah, it's amazing to me, Laura. Max Lowenthal is still kind of acting as an emissary between Burton Wheeler and the administration. and his friends Tom Corcoran and Ben Cohen on reaching a possible deal on court packing.
And that I never would have known had it not been for you, Brad, because I was puzzling over this handwriting I had found in the Frankfurter papers, and I sent it to you in desperation. I could make it out, but I didn't know who'd written it. You said, you know his handwriting, that's Max Lowenthal. And then everything fell into place. So thank you so much.
This is just one archive rat helping another. So we do it all the time.
I appreciate it.
Oh, my pleasure. I want to ask you about a few more things and then go to some questions. But the first thing is, I've recently taught in Con Law 1 both FDR's speech on March 9th and his Constitution Day address, in the fall on September 17th. Is he the last American president, Laura, to give a kind of a big picture constitutional interpretation or a theory of the Constitution in those speeches? I mean, I can't remember an American president, basically really seizing his co-equal role, if you will, in interpreting the Constitution and putting forth a kind of federalist, if you will, interpretation of the document. I mean, has anybody ever done that since?
I can't think of anyone who's done it with that effectiveness. And what's incredible about that Constitution Day speech, which is written in part by your guy, Felix Frankfurter, is the way it reinterprets the defeat of the court bill as a victory, the way it holds out a vision of the Constitution as the guarantor of mass prosperity, the way it roots a faith in democratic constitutionalism as a defense against the kind of democratic backsliding that you see going on in Europe, as Gerard Maglioka has shown, and the way it knocks the lawyers. And I really get a kick out of the way it knocks the lawyers. They've misinterpreted the Constitution for years. They did it again. The Constitution is, a layman's document, not a lawyer's contract. It's a fascinating speech.
That's my favorite line in the whole speech, right? The layman's document, not a lawyer's contract. And it has kind of an echo of John Marshall and McCullough, right?
Yeah.
It doesn't have the prolixity of a legal code, right? And I love that line in the speech, and it's unclear if Frankfurter wrote it or Corcoran wrote it, but it's a great line.
It is a great line.
So I want to ask you about a few more things and that I think are interesting. One thing is you disagree with the kind of conventional wisdom that Homer Cummings was a hack and he filled his Justice Department in the first term with hacks. And tell me why you think that.
Well, this view of Cummings was popularized to the press, I believe, by the Frankfurter Circle and Corcoran and Cohen. Now, Homer Cummings was not a legal scholar, right? Okay, he's not Felix Frankfurter, but attorneys general were supposed to tell presidents what they could do rather than what they couldn't do. Cummings has further received a bad, he did appoint his first Solicitor General, Crawford Biggs, who we appointed on the basis of patronage, was without a doubt awful. But Biggs did not argue any of the major cases. And to his credit, Cummings got rid of Biggs and appointed Stanley Reed, who filled the Solicitor General's office with stars like Charles Wyzanski. Cummings has further suffered, I think, because, he's a moneyed Democrat from a part of the country where that kind of person is rare, Greenwich, Connecticut, and he loves parties, and he loves wine, and he loves the Homer Cummings golf tournament that he hosts annually at Pinehurst. And this is all very obvious, but to everyone at the time. But it's also true that he's the longest serving attorney general since William Wirt, that he is regarded as a very effective attorney general in the department, far more effective than Frank Murphy, who succeeds him, and possibly more effective than Robert Jackson as well, who doesn't get to serve very long. And he is regarded as very loyal to the people, and he makes progress on a host of topics from antitrust to crime. So I really like Cummings. And if I hadn't gotten my husband to promise that if I ever told him I was writing another biography to take me out and shoot me, I would write a biography of Homer Cummings. He deserves a great biography. His papers are really wonderful.
I know,
So
at UVA, right?
Yeah, I very much hope someone does it.
Well, I hope you do it. So
No.
I'd encourage you to do it. Let me ask you about two more topics. I know I could do this for another hour, but I know everyone else doesn't want to be on this call for another hour. But you quote a lot of the great newspaper columnists in the book, and why do you think why did you sort of make that choice? And do you think that their views were representative of the American people, or was there another reason why you thought that their views were important?
They were my witnesses. These columnists, for the most part, were overwhelmingly against the court plan and the compromise, the 5-justice compromise. My reasoning was, if they thought that it had as much of a chance of success as they were always saying it did, even as they announced it, then the court bill had a greater chance of success than most people had traditionally assumed. And so did the compromise. They're certainly not, people like Walter Lippmann and Frank Kent are hardly representative of public opinion, but public opinion polling is in its infancy at this time, and George Gallup is cherry picking data to suggest that more Americans are united against the plan than, in fact, polling experts now believe. And so I thought the columnists were good witnesses.
Well, that's fascinating. That's fascinating. And I mean, you can say that again about Walter Lippmann not being representative of the American people, but that's an aside. First of all, I just want to invite anyone in the audience to ask questions in the chat. And before I ask my either last question or second to last question, I have one more question besides the columnist. Is one of the wonderful things about your book, if you could hold it up for us, Laura, and you've done in addition to some of those most amazing archival work I've ever seen, you reprinted dozens of political cartoons about court packing, and it's really a delight as you're reading the book to peruse each of these cartoons. And you and I have talked about some of them, as you were working on the book, but I want to know if you have a favorite or favorites in the book that you could share with us.
My favorite one is on the cover, and this is a Herb Block cartoon, and it shows FDR hearing a liberal Supreme Court, which is what he got out of it. But Congress has fallen out of the bag. He no longer has control over Congress because of the court packing fight. But it means
You want to
a
hold
lot-
that up one more time to show
Yeah.
people in front of the camera? Wow, that's really cool.
It means a lot to me that you like the cartoons because they are from the Basil O'Connor collection at the FDR library, and I just fell in love with them. What I didn't realize was how expensive they would be. And every one of those cartoons, I mean, to add to the $600 Uber ride, every one, I had to hire a permissions editor, a wonderful woman named Roberta Newman. And every one of those cartoons just about costs between $75 and $600 to reproduce. So that you like them means a lot.
Well,
That's
I like them,
something.
and you've preserved them for everyone to see. You know, you've done all this hard work finding them, and now everyone can admire them as they read the book.
Well,
So
there are dozens more, and I
Yeah.
would have had them, but couldn't afford it.
it's great that you chose to reprint them. I'm going to make, kind of one more call for questions. Oh, I see a couple here. Now I'm on it. I've got a question here from Ron Benson. He says, do you use a specific format for taking notes for your wonderful books?
Post-its.
Post-its?
I'm a Post-it junkie.
That's hilarious.
Yeah.
So old school there, Laura.
Yeah. I Post-its. I have them by the case.
And then I've got another question from Nancy Mavidi. She writes, can you elaborate a bit more about the other main theme of your study, this episode contributes to the rise of legal liberalism? And I'm going to add briefly to Nancy's question. Do you think that the switch in time wasn't just about federal and state economic regulation, that it was also about civil rights and civil liberties?
Absolutely. And I think the impact of I thank you for that question. The impact of the court fight was that, combined with the purge of 1938, combined with the sit-down strikes, combined with the defeat of executive reorganization, FDR kind of lost control of Congress. Now, the court bill was a big factor in this. I believe historians aren't supposed to ask what if, but I believe that even if the court fight hadn't come along, something else would have split the Democratic Party from top to bottom, like the Fair Labor Standards Act that pitted the South against the, cheap labor South against the North. The impact of the court fight, though, was that Congress, or part of the impact, was that Congress became dominated by a coalition of Democrats and Republicans for the next 20, conservative Democrats and Republicans for the next 25 years. And no one realized that better than Lyndon Johnson. At the same time that Congress was being closed off as a locus for reform, though, Caroline Sodek and its issue ensure that the court, which has so recently been the scourge of liberals, will begin to protect, will show even more devotion than it has shown in the past, because it has shown some to protecting civil liberties and civil rights.
Yeah,
So
you write about the DeJong case, and I'm sorry to interrupt you, Laura, but in your book, you write about the DeJong case, as kind of this, early sign, that the court is going to start to protect civil liberties in, say January of 37, that the court isn't just liberalizing on economic legislation, but also in protecting civil liberties.
Yeah.
So I got a couple more questions. This next one is not a plant for me. It's from Philip Tavlian. He writes, was Professor Frankfurter caught between his friendship with Justice Brandeis and friendship with FDR?
I'm going to punt that right over to you, Brad.
The short answer is no, right? He was angry with Brandeis and sided with FDR, and as I wrote in my own book about Frankfurter, it almost cost him his friendship with Brandeis. That it was nearly they nearly broke over court packing, and it took I don't have this on great authority, but some people think that Julian Mack, the great Jewish federal judge and good friend of Frankfurter and Brandeis, had to kind of act as an intermediary so that they could preserve their friendship. Frankfurter was really angry about the letterings and also some of Brandeis's votes against the administration. And Brandeis, on the flip side, was really angry that Frankfurter didn't speak out against the court packing plan and that Frankfurter remained kind of publicly neutral. And who knows if Brandeis knew that Frankfurter was actually helping the court packing plan forces behind the scenes. But I know they were.
He suspected it, don't you think?
I think they were unhappy with each other.
Yeah,
right.
But as you point out, Brad, in your book, in your wonderful book, Brandeis still gave Frankfurter $2,000 because of for their joint venture in 1938, which is the equivalent of over $40,000 today. So how badly were they rent?
Well, I mean, but my one theory I have, I can't prove it, is Frankfurt. Part of the reason why Brandeis was so angry about court packing is that Corcoran and Cohen were trying to get him to retire, to make way for Frankfurter, and he refused. And as I tell people, it's not an accident that Brandeis retires a week after Frankfurter joins the court. He just refused to let Frankfurter sort of push him off the court, and Frankfurter's, acolytes push him off the court. That's kind of a fascinating subplot. One more question, Laura. Arthur Ainsberg writes, I've spent significant time studying Charles Evans Hughes. I wrote a book about Elizabeth Hughes, his daughter, who was also a founder of the Supreme Court Historical Society. And he asked you, Laura, did you review Hughes's papers in your research? Any thoughts on why there has not been any Charles Evans Hughes biography since 1952? And that last part is a great question.
It's a tremendous question, and I encourage you to do it. The Pusey biography, which is 2 volumes, is massive, and it's a great read, but it's time for a new look at Charles Evans Hughes. We have the Simon book, which is very good, but I think a full-fledged, but that's more on the focus between FDR and Hughes. I think a full Hughes biography would be great. And I also think it's time for a new look at Harlan Fiske Stone.
Those are great subjects. So calls to historians. There are many legal historians on this call, I can see. So for those of you legal historians who are listening to Laura Kalman's wisdom, take up the challenge and
after Homer Cummings.
After Homer Cummings, then embark on Charles Evans Hughes or Harlan Fiske Stone. Laura, this is amazing. I really appreciate your spending time with us, and I know that you're still recovering, right? And you're not 100%, and here you are still with us, talking about your book. And this was really fun for me. I hope it was fun for you.
Oh, it was total fun for me. And thank you so much, Brad and Jennifer, and the entire Supreme Court Historical Society.
Thank you, Laura. Thank you, Brad. This was a terrific talk, and we're very grateful to you for joining us today. For everyone who registered in advance, you will receive a survey tomorrow morning. We take your feedback very seriously. We are always looking for feedback and suggestions on possible topics and speakers for the future. So look for that in your inbox tomorrow morning. Copies of Laura's book are available from the Society's gift shop at www.supremecourtgifts.org. So you can find it there. You can find Brad's books there as well. So I hope you'll stop in and take a look. And you should check our website for future lectures. We will have a DC Emancipation Day lecture posted in the next week. And we have John Mikhail from Georgetown speaking for Law Day on May 2nd at noon. On his topic will be James Wilson and the phrase, "We the people." So thank you all for joining us this evening. We are adjourned. Good night.
Thank you.
Thank you.